Imagine you're driving through the heart of upstate New York, more than 100 miles from the nearest international border, when you're suddenly ordered out of your car by a federal agent who demands to see your papers. When you ask what authority they have to seize you so far from any border, the agent simply points to his firearm and says, "That's all the authority I need." This isn't a scene from a dystopian thriller. It actually happened to a sitting U.S. senator, and it reveals a terrifying legal reality that affects 200 million people. Most Americans believe the Fourth Amendment is a universal shield protecting them from unreasonable searches and seizures. But for 2/3 of the population, that shield has effectively been shattered. We are living in what experts call the 100-mile border zone, a vast geographic ring where the government has granted itself extraordinary powers to bypass the Constitution. You might think you're safe in your home or that your digital life is private, but law enforcement has identified 3 massive loopholes, one in the air, one in your pocket, and one at your front door, that have turned your privacy into an optional courtesy. The first loophole is geographic, and it's why 200 million people currently live with diminished constitutional protections. In 1952, the Immigration and Nationality Act authorized agents to perform warrantless searches within a reasonable distance of the border. 5 years later, the Justice Department unilaterally decided that reasonable meant 100 air miles. There is no record of how they arrived at this number, yet this single regulation expanded the Border Patrol's jurisdiction to include the entire eastern seaboard, the entire state of Florida, and nearly all of California. Within this zone, the government argues that its interest in securing the border outweighs your modest expectation of privacy. This allows for roving patrols and checkpoints where citizens are arrested at a higher rate than non-citizens, creating what residents call a band of isolation, where you are perpetually under a state of government suspicion. The second loophole is sitting right in your pocket. While the Supreme Court ruled in the 2014 case of Riley versus California that police generally need a warrant to search your phone because it contains the digital record of your entire life, they've found a way to track you for 90 days without ever touching your device. Law enforcement agencies are now using a tool called fog reveal to purchase billions of signals of commercially available location data from the advertising industry. Every time you use an app that tracks your location, you are likely agreeing to terms that allow that data to be sold to brokers. Because you voluntarily shared this info with an app, the police argue they don't need a warrant to buy it back from a data broker, a legal gap known as the third-party doctrine. They can draw a virtual geofence around your home or a protest site, identify every device present, and then track those devices' movements for months to see where you work, who you visit, and where you sleep. But what if they do get their hands on your physical phone? This leads to the biometric trap. Under the Fifth Amendment, you have a right against self-incrimination, which means the police cannot force you to tell them the passcode to your phone. The court views a passcode as a combination to a safe. It exists only in your mind, and forcing you to reveal it is testimonial. However, a recent case called United States versus Payne has blown open a loophole for biometrics. The court ruled that your fingerprint or your face is not a combination. It's a key. Just like a blood sample, a key is a physical object. In the Payne case, an officer forcibly grabbed a suspect's thumb and pressed it onto the sensor to unlock the phone. The court ruled this was legal, even suggesting that an officer could unlock a phone while a person is unconscious because using a physical key doesn't require cognitive exertion. If you use biometrics, you are essentially leaving the key to your digital home under the mat.
The third, and perhaps most ominous loophole, has recently appeared at the threshold of your front door. The Fourth Amendment was written specifically to end general warrants that let soldiers search homes for any reason, establishing the knock and announce rule and the requirement for a warrant signed by a judge. But a 2026 Supreme Court ruling in Case versus Montana has fundamentally changed the standard for home entry. Traditionally, police needed probable cause, specific facts suggesting a crime, to enter without a warrant. Now, under the emergency aid or welfare check exception, the standard has been lowered to an objectively reasonable basis to believe someone might be in danger. In the case instance, police waited 40 minutes before entering, yet the court still upheld the entry as an emergency. This squishy new standard means that if a neighbor calls and claims you're acting strange, police can bypass the judge entirely. Once they are inside for a wellness check, the Plainview Doctrine allows them to arrest you for anything suspicious they see, turning a help call into a warrantless search of your entire life. This shift represents a move from front-end accountability, where a judge must approve an entry, to back-end forgiveness, where the damage is already done and the search is justified after the fact. When you combine the 100-mile border zone, the third-party data tracking, and the new welfare check standards, the legal definition of privacy begins to look like a relic of the past. The consequences are practical and immediate. If you are a gun owner, your legal right to own a weapon can now be used as a risk multiplier to justify more forceful police tactics during these welfare checks. If you are one of the millions of people with a mental health condition, these unpredictable interactions in the confined space of your home are where tragedies are most likely to happen. To protect yourself, you must understand that these rights only exist as long as you exercise them. The most common mistake people make is believing that cooperating or having nothing to hide will protect them. In reality, consent is a voluntary waiver of all your constitutional protections. If an officer asks to see your phone or enter your home, do not argue, do not get angry, and do not say, "I know my rights." Instead, remain a polite, broken record and say exactly 5 words, "I don't consent to searches." This forces the officer to go to a judge and prove their case with facts, rather than relying on a roadside wrestling match. Additionally, you should reconsider your digital security. Criminal defense experts recommend turning off biometrics like Face ID and Touch ID entirely, replacing them with a long alphanumeric passcode. Because a code is a combination of your mind, it remains protected by the Fifth Amendment in a way your fingerprint does not. Regarding your home, communicate through the door or a window during a welfare check to show you are safe without opening the door, as choosing to remain silent can actually feed the emergency narrative police use to justify barging in. The Fourth Amendment was intended to make your home your castle, but in a world of 100-mile zones and digital tracking, the drawbridge is currently down for 200 million of you,